Hello, dear students. My name is Gaurav Pingle. I'm a practicing company secretary based out of Pune. I'm also a visiting faculty for company law and investment and securities law at ILS Law College, Pune. And I have been writing quite a few articles for the students and members of the company secretary, the chartered accountants, and also cost accountants. I have been allotted a topic which is quite interesting for the students, actually members, but I will ensure that the topic is equally important for the students. The topic that we will be discussing today is interpretation skills and interpretation of statutes. This I feel is a topic which is relevant for all professionals and all students. This topic has got significance because in India we have in last 4 to 5 years at least we have been seeing rampant changes in the law or introduction of various laws. So now when you say you have to interpret a particular statute, then what does this actually mean? That is what we will be discussing, and how to read a particular statute, how to read a particular section, how to read a particular explanation, how to read a particular proviso to the particular section, how do you read a section in relation to an explanation and a proviso. So this is actually a very practical subject because as students you would have definitely come across certain examples, but the purpose of explaining or discussing this particular topic is that I want to bridge the gap between what is there in the books and how it is actually interpreted, right? So this topic or this presentation that I'm making for maybe whatever the allotted time, I will be ensuring that this is relevant for you as students, and after you start your practice or get into employment, this topic will be relevant for you even after that. That is the entire purpose of my presentation. So I will be simultaneously referring to my presentation. Yeah, so today's topic is interpretation skills and interpretation of statutes. Just to tell you, I may take a small pause just to drink water. I am means my the means there is a means I'm not well a bit, but it is nothing to do with corona or COVID-19. It is just a small throat problem that I have because of talking or the speak the talking or the speaking. So I have to drink water or take a quick medicine if at all required. Yeah, so just before we start, would like to discuss what we will be discussing in the coverage and also the present scenario. If you see the present scenario, the COVID-19, it has actually halted the world for around 2 to 3 months, and all the scientists, all the doctors are just working maybe 25 hours a day to get a particular solution for this particular epidemic that is there, the pandemic that has been created. So since we are all working from home, at least for the time being, or we have been, you can say very frankly, stacked in our home. So how you utilize this time is equally important, right? So I am not against any web series or a portal, but as students, whether it is a CA student, CA student, CA, CW students, or any student, I feel that they need to invest a lot of time in uh, the time that they have. This may be in the form of the soft skills that you develop. It may be in the form of certain skills that you develop, which is relevant for the profession. It may be you may develop a reading habit, you may develop a writing habit, and what you read and what you write now is what you become over a period of time, is my observation. Like for example, if you have been reading a lot of business newspapers for say from today till the next 2 3 years, your perspective will be towards business, entrepreneurship, corporates, India INC, what is happening in FEMA, what is happening in the RBI, what is the status of the monetary policy, what is the situation of the fiscal policy. So that perspective you will be giving. And I feel this is the right time to develop habits, good habits. Okay, so without going much into this scenario, I would just like to move on to the introduction of the theme and coverage of the session. Now, in your CS executive paper, probably which you may appear, or for the exam that you will be appearing whenever it is conducted, you have one subject, and in that subject, you have got one particular topic, which is interpretation of statutes. So, what I will be discussing is like to just to tell you, if you read that particular chapter, you may understand some part of that chapter. I'm not saying that you will not understand. You will understand that because it is not that complex also. But you will appreciate the complexity only when you understand the practical aspect of it. That is how you apply the provisions of interpretation of statute. You understand me? Yeah. Also, just a small thing that I have been taking quite a few lectures in colleges, so I am not very comfortable with this video recording, though I am ensuring that I am comfortable. But I always ensure that the lectures are interactive and it is not a monologue. But anyway, so I just hope that I am teaching in that way that you will understand what I'm trying to tell or what I'm trying to explain. So there would be one or two repetitions, but that is just for the purpose of it gets embossed in your mind of what I'm trying to tell you. So the point that I'm making is whenever you are reading this particular subject or a chapter, you may not understand it fully. The reason is because you have not understood its application. How you apply this particular topic to a particular law. So that is the entire purpose that I am taking this session for. So I may not tell you that this is one principle and you can read this or this is what it is. Second principle, this is the principle. Third principle, explanation. That is not what I am going to ensure. What I am going to ensure is that you are able to understand this particular subject from a practical perspective. So I will be referring to certain provisions of the Companies Act. I will be referring to certain provisions of the rules. I may be referring to the securities law, SEBI Act, or maybe a particular regulation or particular clause. I will be definitely referring to few judgments, either in the presentation or either in the discussion that we have. So how these provisions are applied, right? So the point or the conclusion is that to understand the provisions of interpretation of statute, you need to understand or you need to apply it in a particular law. If you are not applying, it's like, to tell you more practically, you have read a book on how to drive a car. You also have the car, but you are not driving it. But after reading the book, you have applied for a driving license, and it is very sure that you will not get it because you have never tried driving the car. So the purpose that I'm telling you is you need to apply these principles. That is, I'm repeating probably for the second time or the third time, is that you need to understand the application. That is what the entire purpose of my session is. I will be explaining your application of this particular principles that we will be discussing. Okay, so now let's move on to another part, which is the very important part for today's presentation. We have the third slide. The third slide says introduction and why interpretation is important. Now, had this not been a monologue, I would have definitely asked maybe 20 students to explain why you need to interpret. Okay. So just to give you an example, and since I don't have the students that I can ask in the class, like everybody, and this is a very common thing, that everybody has got its own perspective, right? So I hope you are understanding where I'm reaching to. I'm saying that, or the question is that why interpretation is important. That is the question. So the point that I'm making is that every person has got a perspective. Every student, every professional, every family member. Just take an example. Today you decide to move into a different city. Your mother will say no. Just an example. Your father may say, okay, you can do this, but you have to do ensure your safety and quite a few things. Your sister may say, you may go, but you can have food over there. The food in that city is very good. Your brother will be more than happy, okay, go. Right? Your grandparents will be a bit scared. पढ़ तो रहा है बाहर तो जा रहा है but they'll be scared, oh but you know they would like to have you in the family. So what is this? You have created a situation that you are going to go outside a particular city for further education, whether it may be further education or it may be that you are getting a job, or it can be any other reason, but this is the decision. Now how your decision is interpreted, how your family members are looking at it, that is what is called perspective. When it is not a legal topic, that is called a perspective. But had this been a law, then there would be different interpretations. So interpretations are nothing but opinions, interpretations are nothing but application, and interpretations are nothing but perspective of a particular person. I hope though I may be going a bit slow, but I hope I'm able to make a point where it says that what is the meaning of, or why we need to interpret the provisions of a particular statute. Therefore, now I'll come to a very practical perspective. There is a provision under the Companies Act which says that under section 188, which relates to related party transactions, a company may buy, sell, supply of goods and services. I may be referring to this particular provision quite a few times because I have authored a book on this particular topic of related party transactions, and this is my favorite topic, or it is a topic of my interest, always a topic of my interest. So when you are discussing this particular point, that whether a particular whether it is buying, selling, supplying of goods and services. Now the question would be that whether loan is a service, whether loans are goods. Say, take an example: director in a company A is also a director in company B. Okay, common directors. One company is buying, selling goods, so it is a related party transaction, no doubt, because it is falling under that. But now there is no buying, selling of goods, but there is a loan given by one party to another party, one company to another company, where director is interested. So the question would be whether giving a loan is a service, whether giving a loan is a supply, whether giving a loan is goods. This is where you need to interpret the law, and that is where the practical application is to be considered. And I'll come to this again when you have to sorry. So that is one aspect. So just coming to the point, interpretation is an important aspect. Now what skill is required? The skill that you actually require, which is very rare for not just students but also professionals, is reading and understanding. So there is a very the way you interpret a particular provision, the way you interpret a particular judgment, the way you interpret a particular rule in a statute, that largely depends on the reading that you have done before applying your mind for that particular question that you have. Now, why is that important? The reason is, the more you read judgments, the more you read the law, the more you understand the law. Take a typical example. There is again the same example. There are two companies. There is a common director. In one company, there is siphoning of funds. That is misappropriation of funds. Funds have been siphoned to some other company. And now the question before the court is whether there is siphoning of funds or not. That is the question, and that is why the matter has gone to the court. Other party is proving that he's paid exorbitant salary, he's given unnecessary contracts, he's giving contracts, he's giving advances, and the contract is cancelled and advance is written off. There could be n number of facts. Now it is not a straightjacket formula, or it is not a straightforward answer. That if this happens, this happens, this happens, this is siphoning of funds. So I'm coming to a very important aspect that whenever there is this kind of a particular situation, there are always two things that you need to remember. First, you need to understand that there is a particular law, there is a particular statute with respect to, or there is a provision in a particular statute with respect to siphoning of funds. That may fall under mismanagement of a particular company. Under operation mismanagement, the other part with respect to management, it may fall under. That is one. Second is, what is mismanagement? Company that is not defined. But where do you find mismanagement? Is the n number of judgments which are laid down by the CLB, the High Court, the Supreme Court under the previous law, the NCLT under the present law, the NCLAT and the Supreme Court. There could be certain foreign judgments. And then you apply, you read all this, and then you come to a conclusion. Yeah, I think so this transaction may be a transaction which is not in the interest of the members. This transaction is a forced transaction. Sorry. This transaction is a forced transaction. This transaction is mismanaged. This transaction is not in the interest of the company. And then you apply various principles and then you argue before the court. So, reading of a statute, reading of all these judgments gives you a perspective how you can counter the point or how you can prove to the court that there is mismanagement of funds in the company. So, please understand, reading as a student and reading as a professional is going to be one of the permanent things in your life. Right? The more you read, the more you grasp. The more you grasp, the more interpretation skills you are able to apply. Now the question would be, sir, इतना सब पढ़ के क्या होने वाला है? Right? Please understand, if you are going to read, you are going to enhance your perspective. Again, you are going to enhance your perspective towards company law, corporate law, or any law that you like. If that is going to be the case, if it is going to enhance, why you can't take the efforts for that? That is equally important. And I'll tell you one thing, if you read any other journals, magazines, Times of India, Business Standard, Economic Times, I understand those are equally important for you to read. But that is only news. Right? This is a very important aspect. Because you are reading just the news, which is just an update in maybe 600, 700 words. And the judgment is of around 40, 50 pages. You have not understood what the judge has actually said, how he has interpreted the provisions. Therefore, reading is a very important aspect that you need to develop the skill. Yeah, so I have discussed about the interpretation, we have discussed about the skill that is required reading, but what material? This is also important. So if you read all those, cricket pages and sports pages and, all media and entertainment, I don't think you will be able to be a professional, but you need to be a successful professional, right? So we have got Sachin Tendulkar and we have got cricket players. Why Sachin Tendulkar outstanding? Because he has taken efforts to be the Sachin Tendulkar or any other sportsman in Indian sport. So reading will make you a outstanding person. This is my perspective and a bit of my experience. I'm not saying that I'm outstanding, but I can definitely tell you that reading helps in interpreting. I give you one more advantage of reading. For example, when you are reading a particular judgment, you are reading an official document which the court has produced. So you are actually understanding the law from the horse's mouth. Understanding? That is the court. In India, though I am not taking this aspect, but it is very important for you all to understand. In India, there are two things. First is there is a statute which is drafted and presented and approved, and it becomes an act, a bill becomes an act. Everything is done by the parliament. So the law-making authority in India is the parliament, Lok Sabha and Rajya Sabha. This is part of civics. You can read it, or it could be part of your lectures later on. So please understand, making of law is the power of parliament, but interpreting a particular law is the power of the court, or is the right of the court. Right? So courts cannot go and write the law, or parliament cannot come and interpret the law. I'll just repeat the last part. Courts cannot go and write the law, and parliament cannot come and interpret the law, because these are two independent functions, the parliament function and the judiciary function. And that is why, if you are reading the provisions of a particular statute and then you read the judgments, virtually you will be the person who will be having a very unique skill and an updated skill of reading and interpreting a particular statute. Yeah, when is interpretation required? Just to come back to your point, interpretation is required when there are two to three perspectives to a particular sentence. That is the time that the interpretation is required. Just to give you an example, there is a law. Just take a very hypothetical example. There is a law in a particular country which says that at 5 p.m. everybody should drink tea. Everybody, wherever you are, you have to drink tea. That is the just an example. There is a law in a particular country. 5 p.m. everybody drinks tea. Now, is there any point of interpretation over here? Answer is no. But when does interpretation come into picture? When you know there is a particular provision, then there is an exemption, then there is an applicability that from 5 p.m. to 6 p.m. Then you come to a particular situation where there is a lockdown and nobody can drink tea for XYZ reason. Right? How do you prove that you have had tea at 5 p.m.? So these are the critical points where interpretation becomes relevant. Yeah, basis of interpretation. Basis of interpretation is what we will be discussing. On what grounds you are interpreting a particular statute. What is the background? What is your analysis? How you have analyzed? That is what is all about basis of interpretation. What is the law and statute? We'll just come to this aspect. Yeah, statutes are commonly divided into following classes. Statutes are codifying something that is unwritten law. They are declaratory. They may be remedial. Now, what does this mean that the law is a remedial law? It means that there could be a provision in the statute which is providing remedies. That if there is a non-compliance of a particular provision, then there would be a provision with respect to the remedy, or there could be an act entirely with respect to the remedies. Amending, like for example, you have got Companies Amendment Act 2015, Companies Amendment Act 2017, Companies Amendment Act 2019. Now we may have an ordinance in April, or maybe not April now because April not possible, but maybe somewhere in the May, June, July 2020. Just an example. And I also understand that most of the students are doing the company secretary course, or all the students are doing. So I may be referring to the provisions which are relevant for you, where you have either read it or you have implemented, or whether you have interpreted. Consolidating, when they consolidate several previous statutes relating to the same subject matter, with or without alterations of substance. Like take an example, the Insolvency and Bankruptcy Code. There are 3-4 statutes right from the Presidency Township Act to the recent provisions with respect to the insolvency. So these are the ways in which the laws are implemented, or there are separate classes of law. There could be an enabling provision when they remove the restriction. Like to give you a practical example, we had earlier FERA, Foreign Exchange Regulation Act, and then it became a Foreign Exchange Management Act. So what was the earlier provision which was regulating? Now it enables by managing. So from regulating foreign exchange to managing foreign exchange. So is it not an enabling law, FEMA? That is how it falls under the statute, different types of statutes. Disabling or restraining, when they restrain the alienation of property. Now what does this mean? Take a very relevant example, Prevention of Money Laundering Act. That's it. That's the best example for this particular point. Disabling or restraining. So you cannot do any more money laundering because there is a PMLA, the provisions. So that is how the provisions are drafted. Then you have got an act that can be a penal provision or a penal act which can impose a penalty or a forfeiture. Forfeiture is basically the amount that you have paid is not repaid. I just revert in 2 minutes. So now we discuss the object of interpretation. I think so we have discussed a bit about it. But let's come to a very interesting aspect. I'll just read out the relevant part. I'm not sure whether it will be visible or not. This is a part of Hasbury Law of England. It says that the object of all interpretations of a written document is to discover the intentions of the author. The written declaration of those mind, the document is always considered to be. Consequently, the construction must be as clear as to the mind and apparent intention of parties as possible, and the law and as the law permit. So please understand, if you read the latter part, it says that the construction must be clear as to the mind, as clear to the minds. So it basically there should be no confusion or there should be no interpretation issue. It should be that clear. The apparent intention of the party should be clear. So your intentions which are in your mind and what you put on paper, it should be the same. And the second aspect, the third aspect, it says that it should be in accordance with what the law permits. That is a very important aspect. So it should be a legal activity or a legal transaction. So this is what is the point with respect to the interpretation. This is what we also discussed earlier. The function of the court is to ascertain what parties meant by the word which they used to declare the meaning of what is written in the instrument, and not what was intended to have been written. Please understand this properly. It says that to declare the meaning of what is written in the instrument. So to understand the intention of the parties, you need to read the law. You need to read the wordings. You cannot ignore the wording and say that, sir, I had written 800 rupees, but I had paid 700. So now interpret. What will prevail? What will prevail is only the provisions of what is there in the statute or what is there in the agreement. That is the entire purpose of the object of interpretation. I'll come to the last part. I may just skip one or two paras, but I'll come to the last part. It says the object of interpretation in all cases is to see what the intention expressed by the words used. The words of statute are to be interpreted so as to ascertain the mind of legislature from the natural and grammatical meaning of the words which have been used. So the emphasis of interpretation is on the words that have been used in that particular statute book or rule book or a particular document. Very sorry, but I'm genuinely a bit ill. I'll try my best that I don't cough a lot. But just repeating that this is nothing to do with corona. It is a genuine cough. Anyways, we now come to the general principles of interpretation. And now we come to a very important aspect. And now we actually start the topic. After a brief introduction of around 30-35 minutes, now we start with the topic. I hope you all have understood. None of you all are sleeping. None of you all are on the flight mode. None of you all are in any other mode but on the classroom mode, which you need to have. Right. Anyway, so now we come to a very important point which relates to the primary rule of interpretation. Primary rule of interpretation, as the word goes or as the words are there, primary means the first rule of interpretation. When it says first rule of interpretation, it means that this rule is to be applied at the first instance without any other aspect to be considered. And to make it very clear, this first rule of interpretation relates to literal construction. Literal construction. Now, literal means what? Obvious. Or literal means what is there stated in the statute. That's it. There is nothing more than that. It's what is there. And construction. So, what has been drafted, how it has been drafted. So, what is the meaning of the words which are there in the statute is nothing but what is the literal interpretation or literal construction. So the emphasis, please understand, I am repeating this, but it is very important for students to understand. The emphasis of interpretation is all on the words that have been used in that particular statute. I hope you are able to connect with me on this point, though I can't see you all. But I hope you all are understanding this point that words, what you have mentioned, are important. For example, in the olden times, there used to be exchange of letters, and exchange of letters used to determine the intention of parties. There was no telephone, there was no WhatsApp, there was no any other kind of telegram. There was no telegram means the telegram app. There was no way in which they could communicate. So letters was the only thing. So what you put in letters is what you are and what you think that you are. Right? So you cannot say that I intended this but I wrote this. This is a very important aspect when it comes to point relating to interpretation of statute. What is there in the book is what you are, is what is the law. What the provision says, it says that according to this rule, the words, phrases, and sentences of a statute are ordinarily to be understood in their natural, ordinary, or popular and grammatical meaning, unless such a construction leads to an absurdity or the content or object of a statute suggests a different meaning. So, whenever it is natural, ordinary, and popular grammatical meaning, you have to go by that. You cannot say that, sir, there is a problem in the statute, it is not drafted properly, object is different, and all. First is read the law, read the letters, read everything, and then if at all there is a problem, then we may refer to the rule. But the primary rule is literal interpretation. There are a few judgments. Interpretation should not be given which would make the other provision redundant. We will come to this aspect later on. Discussion on the first rule. So whenever you have to construct a statute or construe a statute, construe means an interpret, or document, you do not construe it according to the mere ordinary general meaning, but according to the ordinary meaning of the words applied. You need to see in what context they have been applied while preparing a document or a statute. We now come to a corollary. It says that a corollary to the general rule states that little construction that nothing is to be added to or taken from a statute unless there are adequate grounds to justify inference that legislature intended something which it omitted to express. So you need to go by the literal construction, or you need to find out a particular provision which the legislature, that is the parliament, has not included, then that may be inserted. But that is all ifs and buts. Primary rule, go by the words. Just to again extend the discussion, every word in the law should be given the meaning, as no word is unnecessarily used. This is a very important aspect. Every word has got a meaning, every proviso has got a meaning, every explanation has got a meaning, every that is used in a particular statute or a section or a subsection is important. There is a reference of the but not a, there is a reference of a but not the, there is a reference of or and both are used, or one of them are used obviously. At that point of time you have to read the law. You cannot read or as and as or any other substitute, because the law is very clear. Okay. Okay, so just to give a small recap or one more point is that when you are saying about the provisions with respect to the first principle of interpretation, basic provision says that, or to there is another principle which is called as the golden rule of interpretation. So golden rule and the basic principle of interpretation are one and the same. It may happen that you may not have this particular principle which is the first rule of interpretation, but everybody in all the judgments they may refer as per the golden rule of interpretation, words are important. Okay, great. So I hope you have understood the first rule, because if you have understood the first rule, you will be in a situation to understand the other related rules. So now we come to the next point, which is the mischief rule or the Hayden's rule. Now you have to understand this from a very practical perspective. And to give you, see, if you know the law and you have got a wicked mind and you know the law, you know how to break the law. And this is very common, not just in India, but all over the world. You know the law, you know the loopholes of the law, you have got a wicked mind, or you want to break the law and you want to prove that you have broken the law, then in all these cases, you will be a person who may be just not you, not exactly you, but you may be the person who will be taking action against a particular company, or a company may be taking certain decisions which are not in the interest of the shareholders. So you will be violating the law, you will be breaching the law. Now, as I said earlier, we need to connect this. To give an example, the Companies Act 1956 was applicable from the year 1956. But from 1956 to 1975, there was no provision in the Act, that is almost 19-20 years. There was no provision in the Act whereby the company can raise deposits. Right? Deposit means public deposits. So what was the understanding? If there is no provision, means there is no prohibition. If there is no prohibition, then we can go and raise deposits. So companies didn't issue shares, equity shares or preference shares. Company didn't issue debentures. Company didn't issue bonds. Company didn't issue warrants. But they created another instrument that was called as deposits. These deposits were repayable. The deposits had an interest on that. The interest was cumulative. And most importantly, there was a default. So you raise money 100 rupees through capital and you raise 600 rupees through deposit. The question before the government at that point of time was, in 1975 or 1974, is that there is a requirement of a law or an amendment to the law with respect to deposits. You need to define deposits. You need to regulate deposits, because ultimately it is public money. And in the year 1975, the Companies Act 1956 was amended by introducing section 58 capital A, 58 double capital A and 58 triple capital A. Now because of this, there was a need of specifically a provision like this, and that was introduced. Now please understand, that is where the mischief rule is to be applied. Mischief rule means that you did a particular transaction before 1975. Now after the law is amended, you want to do certain more things. But now the question over here is, whenever there is a fraud after 1975 in collection of deposits, the question is, will you apply the hidden rule or the mischief rule? You may. Answer is you may, because there is a background that has been created with respect to the situation with respect to raising of deposits. So whenever the deposits are raised by a public company or a private company in accordance with the provisions of the other regulation, that time if there is a non-compliance in the provisions, then in that case there could be a situation where you may have to apply the provisions of Hayden's rule or the stiff rule, right? So I'll just read one point and you'll understand. I'm very sure about that. In Hayden's rule, in Hayden's case it was resolved that for sure for the sure and true interpretation of statutes in general, four things are to be considered. First is common law before making the act. What was the mischief and detect for the common law? What remedy the parliament had resolved and appointed to cure the disease, and the true reason of the remedy. If all these four conditions are satisfied, the interpretation of the perspective towards the law will change. But please understand, this is to be considered only in the case of mischief. Only when there is a mischief that is being played by few promoters. It is not to be considered in all the. Now we come to the third rule of interpretation. This is called as the reasonable interpretation. Please remember that the principal interpretation of statute and the golden rule of principle is always the first principle and always the important principle under the interpretation of. So normally the words used in the statute have to be construed in their ordinary meaning, but in many cases judicial approach finds that simple device of adopting the ordinary meaning of words doesn't meet the end of fair and reasonable construction. So what this law says is that you have to read the law with an intention of a reasonable interpretation, or it could be a reasonable construction in the statute. So according to this rule, the rule of the statute must be construed so as to give a sensible meaning to them. A provision of a statute cannot be interpreted as to divorce it entirely from common sense. Every word or expression used in the statute should receive a natural and a fair meaning. I hope you all have understood this point with respect to reasonable construction. You need to be reasonable, but at the same time you need to apply the provisions in the what is there with respect to the particular statute. So now let's come to another rule of interpretation. This is the fourth rule of interpretation. This rule relates to, or the title of the rule is harmonious construction. Now what is your view about what is the meaning of harmonious? Now I know that you can't answer, but what you can at least think of harmonious, or you would have gone to certain what is the name of the hotel is harmony. So what is harmony or what is harmonious? Just think. I know I can't ask you one to one, but you can just think for at least 5-10 seconds of what does harmony mean. So harmony basically means peaceful, right? Or none of the parties are affected, or none of the people are affected. That is harmony. So you live in peace, you live in harmony. That is what we generally say. So when you say about harmonious construction, this is a very important aspect. Like, to give you an example, to give you a practical example without going to the provisions, there could be one transaction, but there could be two provisions for that, or more than that, maybe three or four provisions for that. So what is a transaction? Transaction is for investment guarantee security by a company in another company or to another company. Now the question would be, which provisions are applicable? The provisions of section 179 subsection 3 are applicable. Why? Because the company is giving loan guarantee security, so certain matters to be discussed by the board of directors only at a board meeting. There will be a provision under section 185 that may be applicable because that provision relates to loan to directors, which include guarantees and securities. There are certain transactions which are exempted, there are certain transactions which are permitted, there are certain transactions which are prohibited under section 185. And the third part, or the third provision which is applicable, is section 186. Section 186 imposes or provides for monetary restrictions on investment loan guarantees and securities by a company to another company. That is what is section 186 relates to. Therefore, when a company is going to give a loan guarantee security, you need to consider from the perspective when a company is giving a loan guarantee security, you need to harmoniously construct, harmoniously interpret the provisions of section 179, 185 and section 186 of Company Act 2013 for that particular transaction. You cannot, and that is where harmonious construction is there. And another principle, that if a particular transaction is falling under 2-3 provisions minimum, then you cannot comply with only one provision and say that yes, that's it, the company has complied. You cannot give a loan guarantee security only by passing a resolution at a board meeting. You need to check the limits, you need to check to whom the loan is given, and then accordingly you can include it in the specific limits. That is what is called. So again, it comes to another aspect, that you have to read the law and you need to apply the law. But again, going back to the first principles, words in the law are not irrelevant in such a way sorry, words of the law are not irrelevant in such a way that you cannot read these provisions and interpret the law. Each and every word in the law or a statute has got a meaning, and most importantly, it has got an importance. So a statute must be read as a whole, and one provision should be construed with reference to another provision in the same act so as to make it consistent enactment for the whole statute. Where a construction has merits of avoiding any inconsistency or repugnancy either within a section or between the section and other statute. Yeah, so the next slide is also about harmonious construction. Sorry. Now we come to another aspect. This point relates to what is called as the jusdem generis principle. Okay, I'll give you certain examples. If you refer to the provisions of the SEBI Act, SEBI can impose a penalty on the parties that have not complied with the provisions of the SEBI Act or Securities Contract Regulation Act or relevant provisions of the Depositories Act. Yeah, I was referring to one provision in the SEBI Act that SEBI can impose a penalty on certain parties if they have violated the provisions of the Act that we have already seen, whether it is the Securities Contract Regulation Act or the Depositories Act or any other provision. However, when we are imposing a penalty, there should be 3 points. Okay, or SEBI should consider 3 points. Those are referred to as factors for consideration for the purpose of imposing a penalty. And that is a very important aspect. So the question would be whether SEBI is only required to consider the 3 points, because at the end of the third point there is a particular clause which says etc. The first point says when a SEBI is imposing a penalty on a party, first is gravity of non-compliance. Second point is impact on the market conditions. Third is how much the investors are affected, and etc. So the question over here is, for the purpose of applying the principles of jus cum generis, how to interpret extra, or how to interpret one more point which says that instead of extra, it says that or any other provision or any other reason. So the provisions of jus cum generis are very important from the perspective of application of a particular statute or interpretation, specifically in relation to the point where you have got the reference which is either etc. or maybe in a very elaborate form. Now when you are referring to the provisions of jus cum generis, that time what it says that the last word in that particular sentence should have the color and the meaning of the earlier words. So when you are saying etc. or maybe or any other reason, or maybe you are using a very wide language, the question would be how will you interpret this particular provision? You need to understand that you need to apply what is the meaning given to the three conditions. That will be the meaning that would be given to the fourth condition or the fifth condition. Okay, I hope you are understanding this point. Like for example, just an example, I don't know the facts. It says that to take an admission in a college or maybe a particular course, you need to be a 12th commerce graduate, or you need to have completed 12th arts, or you have completed masters in any other course. Now how will you read on any other course? That is where the principles of jus cum generis will be applied. First 2 points were commerce, third point was a bit vague, and therefore you have to introduce the provisions of the third point by applying the principle of jus cum generis. Yeah, if you have got queries, I know that this is being recorded, but my question or my humble submission is that if you have got queries, you can email to me. I will be replying to your queries if you have any, or if you need any help, I will be able to assist you. So it becomes a good communication as well as it becomes helpful for the students in interpreting a particular statute. Yeah, so now we come to when and how do you apply the rules of jus cum generis. To apply the rules of the following conditions must exist. First is statute contains an enumeration of specific words. So commerce, art, science is enumeration of specific words. The member of the enumeration constitute the class, which is the types of colleges. The class is not exhausted by enumeration. So there could be few more fields and faculties that could be considered in the 3 points or the streams that we are having. The general term follows enumeration. So there will be an enumerated point and then there will be a point which would be in a general sentence or a general term. The 5th point says there is a distinct genus, that is a type, which comprises of more than one species. There is no clearly manifested intent that general term of certain to give a broader meaning that the doctrine requires. You can read this aspect about the jusdom generis later on. We now come to another Latin phrase which is quite relevant from the perspective of interpretation. It relates to the rule means that express mention of one thing implies exclusion of other. Very simple and very easy to understand. What does it mean? That express provision for one transaction, it means that the law doesn't apply for the other transactions. I hope you are able to understand. For example, I'll give you an example, and this is again a hypothetical example. There is a law in a particular country which says that a company can issue shares. That's it. They don't have debentures, they don't have deposits, they don't have anything. Now the question is how you will interpret that the company shall issue only shares or the company shall issue shares and not any other security. Is the way in which you consider this point sorry is the point about this Latin phrase, which means that the express mention of one provision or a thing implies exclusion of another. You can read the latter part, but this is the important point of interpretation. Then we come to the next point of interpretation. Again, what is there in the heading is a Latin phrase. The maxim says that the best way to give a meaning to a document or a proposition is to read it as it would have read when it was made. So what does that mean? It means that the person needs to step into the shoes of the person who is party to all these transactions and understand what was the thing where it will be applied a bit earlier, and therefore you have got this particular provision which says that the best way to give effect to a particular document or a proposition is to read it as it would have been read when it was made. Yeah, I suggest you all to just read this part, but there is one very interesting phrase, and I think so you need to always have this understanding. It says that the Latin phrase, it means that it is known by its associate. So it is something like a person is known by the friends he keeps. The person is known by the books he reads. The person is known by the people he talks. That is what it means, right? Similarly, you have got for interpretation which says that it is known by its associate. So when you are interpreting a particular word or a statute, you may apply this particular test which says that it is not a simple principle in interpretation of statute to lay emphasis on one more word disjuncted from preceding and succeeding words. You will understand this when you start applying, so I may not give you a lot of examples. Okay guys, so I will give you some food for thought. Now enough of discussion through PPT. let's now discuss something which is very relevant for you students, and there could be some students who have completed their articleship or the internship. There could be some students that they are working as interns. There could be some students who have not enrolled at all. So now I've got a different set of not queries, but I've got a different set of a question. The question is, how do I address all these persons at the same go? Now let's come to clause by clause. Right, I've got at least few points in my mind about what are the interpretation issues in the Companies Act. And if you want to really understand and apply the provisions of the Companies Act, at that point of time, you need to read few interpretation, the principles relating to interpretation of statute. Okay. Yeah. So let's come to certain examples. First example, you can refer whenever possible. I may also refer that whether the provisions of corporate social responsibility under section 135 are mandatory. This is a question, that whether the provisions of section 135 are mandatory. And if you read the relevant provision, it says that every company to whom the provisions apply shall spend 2% of the net profits of the previous financial years. So that is how you need to interpret shall and may. That is the first point. Okay. Second point, if you refer to the provisions of section 42, section 42 relates to, you see the title of the section. Section 42 relates to placement of shares. However, when you read the entire provisions of section 42, there is no reference of shares. There is just a reference of securities. I hope I am able to connect with you on this point. And there could be one more example. Just understand the situation. The Ministry of Corporate Affairs had issued a notification dated 5th June 2015. 5th June 2015. The question is, whether, yeah, that is one. So there are certain exemptions that are given. I'm coming to the practical point. Second point or second point in the case. In the year 2017 and 2018, the government amended those provisions of the same provisions which was there in the books of account, or which was there in the books. Now the question is, how will you apply the provisions of interpretation of statute when there is so much of complexity involved? There is a notification given, then there is a circular that is issued, then there is an amendment act, and everything relating to one person. How is it possible? And even if it is possible, how is this helpful? And that is the place, whatever we discussed in the earlier part, you need to understand it thoroughly. So what does that mean, you need to understand it thoroughly? It means that you need to literally apply your mind when you are finally concluding with your interpretation. I have seen quite a few professionals and students, they just talk and talk and talk, but when I say that, okay, that's fine, you give me on a piece of paper, I'll understand, I'll read and I'll reply. Not able to do that. Okay. So please understand, that is the point where there are certain more provisions. Now let's come to one more point. The Ministry of Corporate Affairs or the Parliament passed the Companies Act, section 188, again, related party transactions. Okay. There was one particular case in a company where the company was buying and selling of goods and services. Okay. And there are, if you refer to the provisions of section 188, there are so many provisos, at least 5 to 6 provisos that I am aware of. Now, what does a proviso do? A proviso, please understand this, proviso creates an exception to the statute or that particular provision. And the provision that continues to remain in the provisions of the regulation is what is there in the provisions with respect to interpretation of statute. Yeah. So now we come to another point of another example where interpretation issue could be there. If you refer to section 62 of the Companies Act 2013, it relates to issue of shares on a proportionate basis, that is rights issue. Now, whenever a company is proposing to issue shares to its existing shareholders on a proportionate basis, to all the existing shareholders on a proportionate basis, the provisions of section 62 will become applicable. 62(1)(a) more specifically. But just take an example. Under the Companies Act, there is a proposal. Take an example, in a private company, there are only 4 shareholders. And to all the 4 shareholders, the company proposes to issue debentures, which is not shares, on a proportionate basis, on a rights basis. Now, is it possible? Answer is no, because at least according to me, it is no. Because if you refer to the provisions of section 62, section 62 relates to shares. And if you refer to the provisions of section 71, which relates to debentures, and if you refer to the provisions of section 42, there is a reference of securities. So there is a gray area, or there is a provision where it is not, you are not able to come to a solution, because various sections use various terminologies or various you can say words where the interpretation becomes difficult. This is one example. Second example, under the Companies Act, section 62 again, subsection 1, clause C, there is a provision which says that if a company proposes to offer shares to a person or a select group of persons, then they should comply with the provisions of section 42 read with the provisions of section 62 1C. Okay. Therefore, the concern over here is how can you interpret section 62 1C? If you come to the provisions of section 42, it is exclusively about private placement of securities. If you come to the provisions of section 62 1C, it is private placement of shares, because section 62 relates to only shares. And this is where there is a problem in the interpretation of statute, or there could be an interpretation issue. I'll take one more example, probably I may have discussed that, but just to connect you to that particular situation. In 2015, the government issued a notification and granted exemptions to private companies. Okay, the private companies were granted exemptions for 1, 2, 3, 4, 5 sections, whatever the number of sections they are. Total 10, 15 exemptions. However, there is a particular clause or there is a particular point which needs to be considered here. 2015 में notification आया. In 2018, the Companies Amendment Act was passed and notified. Okay. Now the question over here is, in the Amendment Act, there is one particular provision in the Companies Act for which there was an exemption in the year 2015. The Act was amended in the year 2018. And this is a typical question which all the professionals always come, and probably you a student. Will the exemptions given to private companies continue, especially when especially when there is a specific provision? And that is the point where you need to interpret the provisions of the Companies Act 2013, obviously in the light of interpretation of statute. That how is this possible? Under section 62(1)(a), which relates to shares, section 62(1)(c), which also relates to shares, and section 42, which relates to private placement of securities. So that is the place where the provisions will be applicable. Okay, so now let's come to the one more point, which says that now see there are aids or there are assistance that we can give for the purpose of interpretation. Some how you have got props. So there are some internal help where that is required for the purpose of interpretation. So first is title. So if you refer to the title of the chapter, you can get a particular idea of what it relates to. Then you have got a preamble. Every act has got a preamble. Now what is this preamble? Preamble is something like a background to the act or a background to the bill, right? So to give an example, to give you an example of Companies Act 2013, what is the preamble? Preamble is like this is just an example. You can check that, but it would be somewhere relation to what I'm talking about. Companies Act 2013 shall consolidate all the amendment acts till date. First one. Second is it shall efficiently monitor the compliances of companies. Third one, to inculcate a good corporate governance structure in the company. These could be the preamble. These could be the, you can say, the theme or a motto of a particular act. Heading and title of the chapter, that is the case which you can have. There are marginal notes. Now this is very interesting, marginal notes, like whether marginal notes can be referred to and can be considered for the purpose of interpretation, right? So what are marginal notes? Marginal notes are the notes which are maybe just below the section or just next to the section. Right? So you have got a, you can say an A4 page, and certain columns on the right and left side are kept vacant so that you can write when you are drafting the law. These are referred to as the marginal notes. Actually, if you see, marginal notes are just, not just one or two lines. It may be running into one or two paras. So the question is, what are marginal notes and whether marginal notes are binding on the person to whom the provisions are applicable. Then you have got an interpretation clause. What would be an interpretation? If you have got a particular provision in a particular statute, say take an example, the definition of securities. Okay. Definition of securities is defined only in Securities Contract Regulation Act. Definition of securities is not relied upon or not in a particular manner in which it is or it ought to be. Now in this particular case, Yeah, I was referring to the definition of securities. Now, if you refer to the Companies Act doesn't define securities. It says go to provisions of SCRA, Section 2, Clause F or H. You go to the Depository Act, that also doesn't define the securities. What are that securities that get tie up and get listed on the stock exchanges through NSDL and CDSL? So even that is not applicable because Depositories Act don't define securities, but they give a reference. Whenever there is a securities, refer the SCRA. If you refer to the SEBI PIT regulations, there is reference of securities. That refers to the provisions under the SCRA. And there is a provision under the takeover code with respect to the securities and the control. So wherever there is definition of securities, it says go and refer to the provisions of SCRA, which is the regulation that you are reading right now. PIT regulations, PFUTP regulations. Then you have got provisions with respect to there is one more provision which says about the provisions of section the definition of securities. There are many provisions. If you refer to the provisions of section 68, it says about buyback of securities. Now, where does this security come from? I'm repeating this, that it is defined in the law what is the meaning of that particular word, and therefore you need to refer that particular section in that law and apply the provisions under the Companies Act. To give you an example, practical example, that whether the shares of a private company are securities, the question. Think on this. Whether shares of a private company, whether one director, two director, or 10 directors, or it may be up to 200 members, whatever is the case, whether the provisions of securities is defined. If not, whether the family or whoever that person is not complying with the provisions of the definition of securities. Think on this for just maybe just 10 seconds till the time I drink water. So when you are considering the provisions of the SCRA, they are to be read. Not the entire securities contract regulation is to be read with the Companies Act. That is not nowhere mentioned. But you need to ensure that provisions of interpretation of statutes will be applicable when you are cross-referring the definitions. And that is the entire purpose of the law. I'm repeating this for the last time. You refer to the Companies Act, definition is SCRA. You refer to the Depositories Act, definition is SCRA. You go and refer to the definitions of maybe takeover code, it is defined. You go and apply to the provisions of the PIT regulations, the provisions are applicable. So therefore, what I'm trying to say is that in the internal aids of interpretation, you have got what is called as the interpretation clause. Now we come to one point, which is a very interesting point, and I am of the view that you can read a lot of material and understand this point. Probably you would have dealt with it practically, but I would like to tell you that this is a game changer to the entire provisions of the Companies Act, and not just any particular section. I can give you minimum 10-15 sections. Anyway, so what does this mean? What is a proviso? Proviso has two functions. Okay, first function is to create a condition, and second function is to create an exception. Okay, I'll give you an example. Hypothetical example, but in relation to the Companies Act. Section 123 of subsection 1 states that a company shall hold an AGM up to 30th of June 2020. This is first point. Second proviso. Second proviso says that it shall be only applicable from 2 p.m. to 5 p.m. on a particular date. They have prescribed time for this particular meeting. Then we come to another point. Okay. Then we come to another point where you need to consider this from the perspective of the shareholders, debenture holders, and the company. That is where you will be applying the provisions of SCRA. Okay. Let's come to one more example. Under the provisions of section 185, there are separate provisions with respect to loan guarantee security. Okay. And there is a proviso which says that such provision shall not be applicable to a transaction relating to loans, guarantees, securities by holding company to wholly owned subsidiary company. Are you understanding? Wholly owned subsidiary company. That means you will be considering this situation only when it is a transaction between a holding company and subsidiary company, or a holding company and a third party. That is where you need to apply the provisions with respect to the provision with respect specifically with respect to the proviso. I'm repeating this. Proviso can create an exception, or proviso can create a you can say restrictions. Sorry, proviso can create an exception, or a proviso can create a exception or a restriction specifically in relation to the provisions of any other statute. Right? I am not discussing this aspect. Interpretation of statute, I am discussing from the perspective of me as a company secretary and you as the students of this particular course. Now, there are many perspectives to that. For example, company law may be applicable to chartered accountants, but maybe some 30-40% of the company law. There could be an advocate who would be into corporate practice. He would also be preferring to have a provisions under the provisions of the you can say the particular transaction. So these provisos after provisos create a lot of confusion in the applicability or non-applicability provisions. So therefore, but also we may discuss this point later, that you as a you can say as a person, you have to ensure the compliance of all the related provisions. Yeah, so just coming back to one of the points with respect to the point of discussion, I would just like to touch upon two remaining points for today's session, which are relevant for the students, and just to conclude on this aspect. So, when we come to the point with respect to the reference of other statutes already discussed, we now come to the dictionaries. So, dictionaries are very important from the perspective of professionals when we are writing an opinion or interpreting a particular provision in the statute. Like for example, if you refer to the definition of loan, right, the term loan is referred everywhere. Right? So you need to understand what is the meaning of a loan in a particular context. Whether advance of salary is loan, that is one. Whether a loan that is given by one company to another company as a part of loan agreement, that is another transaction. Whether a temporary advance for a period of just 10 days is given, but it is not an advance actually, but it is a temporary arrangement, a bridge facility that is provided. So you need to understand what is a loan. In companies like there are certain places where they have used the word funds. Now funds is not defined in the act. Since it is not defined in the act, they will refer to the ordinary general meaning in the dictionary. So these are certain points. Like one more important point under the Companies Act is with respect to say one more important we can say references in the Companies Act. There is reference of a particular word which is called as firm. Firm in which a director is a partner, firm in which a director's relative is a partner. So what is a firm? Whether partnership firm is a firm or a LLP is also a firm. So what I mean to say, wherever there are undefined words in a statute, the legal dictionary meaning will be the resort, and therefore it falls under the external aid to interpret. I hope you are understanding what I'm trying to say with respect to this point on the interpretation aspect. And then we have got a point with respect to the foreign decisions. Now, these foreign decisions are quite important because you may have a similar provision under the Companies Act in the UK or under the US or maybe in Singapore or maybe in a different country. Since there is a complexity in such provisions, there is obviously there could be a similarity of situation, or there could be a similarity in the disputes which will be there between the parties. So now the question is that how do you actually apply the foreign decisions for interpreting the Indian law? There are some inherent restrictions. So through various judgments, it has been observed that the assistance of such foreign decisions is subject to the qualification, that is a condition, that prime importance is given to the language of the relevant Indian statute, the circumstances and setting in which it is enacted, and the Indian conditions where it is to be applied. So this is a very important aspect. There are 3 points. First is language of the statute. Second is the circumstances and settings. And third, where and how it is applied. So these are the points where you can say that foreign decisions will apply. Now take an example. Like you would have studied definitely the case of Solomon versus Solomon. Now Solomon versus Solomon in the UK, I think so 1870 the judgment was passed at that point of time. In the case of Solomon versus Solomon, that there is a separate legal entity and all those criteria, basics about the company law. Now question is that whether is it not a foreign judgment? Answer is yes, it is a foreign judgment. Whether it is binding on the Indian entities? Answer is yes, because of the 3 conditions that have been followed. And we just repeat that. First is the language is relevant to the Indian statute. Second is the circumstances, and third is the setting in which it is enacted and where it is applied in the Indian condition. So these are the points where the foreign decisions will be applicable. Now take an example, like in the case of entrenchment, under section 6 of the Companies Act, there is reference of entrenchment under section 5 and section 6, which relates to the articles of association. So question is whether the entrenchment related provisions which is not defined under the Companies Act under the previous law. Interestingly, entrenchment has also not been defined under the Companies Act 2013. But maybe in certain countries, entrenchment is a word which has been used for a long period of time. So, the question is, can you borrow the meaning? Probably yes, you can borrow the meaning, or you can rely on the foreign judgment where there is a reference of entrenchment. So, what I would like to say is that wherever there are undefined words or phrases or terminologies or complications, you may refer the dictionaries or the foreign judgments. Right? There is no restriction on the jurisdiction that you may refer only to the UK and US and not to some other country. But when it comes to foreign judgments, it is necessary that you are aware of the facts and the Indian context as well, which is mentioned in the slides. Okay, so generally I have a Q&A slide where students ask questions. However, that considering that this is just a monologue in the lockdown and a one-way lecture, it is not possible for me that I discuss or I may get a question on a real-time basis. But since you all are watching this particular not telecast or maybe what you are watching it on the LMS of what the ICSI has introduced or set up. If you have got any queries, you can email the queries. I will definitely respond to it. Just a small request: don't WhatsApp any query because it is much clearer if you send an email, and I may be able to understand and answer accordingly. So, students, I wish you all the very best for your future endeavors. I wish you all the best for your exams, which you may have. I may also wish you best if you don't have exams, but you may have your professional goal or your career ahead. So, great guys, all the best and for your studies and your professional pursuit. If you have any queries, as I said, you can mail me. I thank ICSI for this opportunity, this wonderful opportunity in the lockdown that I can communicate to so many students through the LMS portal or the portal that they are creating and uploading this particular video. So thank you, Shruti ma'am. I also thank SK Jena sir and the team. I am of the view that ICSI has taken a lot of efforts in having this kind of initiative where it will also be helpful for the students as well as the professionals to interact. One just small point which is relevant for all these students is that ICSI has got its own publication on interpretation of statutes of the corporate laws. That the book has been published and the book has been published by ICSI and the book has been authored by Dr. K.R. Chandradre sir. So this is he's basically from Pune and I consider not just me but the entire and I thank students for their active participation during this lockdown. So all the very best and keep in touch and all the best.